apparently there's a big group of people still having coffee outside, and Marta has kindly taken on the responsibility to just, shepherd everybody in. But I think I'm gonna just start a little bit soft. What we're gonna do is we're gonna have the Q&A part of this session and let all of you here, participants here, but also those online to be part of the discussion. So you can ask questions to the speakers. While waiting for the group to come in, I think we can start with a question or something like that. Any questions from the people here?
Max Lyles from the University of Gothenburg. I have questions for Professors Kristina Ramberg and Alexander Helkart. Thank you for two interesting presentations. I begin with Kristina Ramberg. As I understood, the problem that you wish to address was somewhat of a methodological problem, namely that how can one establish a principle or doctrine of stare decisis in an area or a legal system that never has had that understanding of law, namely that case law can also make up a part of law. And what I'd like to wonder is, how do, for instance, lawyers in systems that don't have an express rule with regards to precedents work in reality? What is the reality of their work? What is actually the value that they attribute to decided cases? That was a question for Kristina. And Alexander, I would like to understand that. Does your distinction between regulation connected to the public good, which I understand is regulation proper, and regulation in name only, that is regulation without connection to the public good, imply a material definition of public good, or is it just a formal distinction between that decides whether it's regulation proper or regulation in name only? So those were my two questions.
Well, thank you, Max. This idea of stare decisis or binding precedents, of course, precedents are never binding, not even in jurisdictions who claim that they are binding. They are never totally binding. And this, of course, poses a problem to the Brazilian situation where the constitution states that they are binding. So what is binding and how to understand that? I just wanted to point that out, that is a problem. And of course, in the common law countries, they know how to cope with these problems. They haven't solved them, but they somehow cope with them. But for jurisdictions not accustomed to use precedents as a source of law, this is a challenge, just to understand the nature of them. And of course, we will be greatly helped by all the enormous literature in Anglo-American law. But we, of course, every state needs to find their own way of handling precedents. And then if I understood your question correctly, you say, how do precedents become a source of law in countries where that is not established formally? I think this is a very intricate relationship between the judges and the professors. Because if professors gradually start to treat precedents and present them not merely as illustrations, but as they say, now we have a new rule established by the Supreme Court. If that is how a case is presented in the legal literature, gradually the legal community will acknowledge the precedents and the judges as lawmakers. And this is, of course, a very interesting development, how judges perceive themselves as lawmakers or not. From what I understand, but I hate to summarize English law, but I know that there used to be a debate where the judges merely declared existing law or whether they created new law. And from what I understand, now it's generally acknowledged that they create new law. And just to take the example in Sweden, this is a fairly new thing that judges in our Supreme Courts acknowledge that they create law. And they are not ashamed to say it. They're not afraid to say it. Although some of them don't say it and try to hide behind a facade that they actually create new law. So to answer your question, I think in order for a jurisdiction to perceive itself as partly based on case law, the professors need to help the practitioners to understand this, that this is happening. Do you have a follow-up question to this? No? Thank you.
Thank you for the questions. Actually, I want to add just a small comment on your first questions from my point of view. Because if you want to use case law as an instrument for regulation, then I think this is also a very important thing, that the judges are kind of self-aware of what they are doing and frame their decision in a certain way, because otherwise it won't work. I mean, of course, you can discuss whether you want to have this or not, but if you want to have this and if it's meant to work, then I think it's necessary that you have certain conditions fulfilled. And that is, for example, that the judges make clear that they are not only deciding a single case, but that kind of extrapolate out of the facts of this case something which I have called a typical situation. Yeah, so even if you apply an existing law and interpret it, then you need to show what is the situation you are dealing with. So, for example, German Supreme Court some years ago decided on the question whether it's contributory negligence if you don't wear a bike helmet, if you are involved in an accident as a bike driver, bike rider. And there they kind of refused to make like a regulatory statement by just looking at a statistic saying at the time of the year the accident happened, how many people in reality were wearing helmets in Germany, and that was something like 15%. And so they said it's not a general custom to wear helmets, and so it cannot be contributory negligence if you didn't wear a helmet. So if you do it like this is kind of you refuse to set a precedence with a regulatory implication. If you want to do that, then you have to make clear and have to say, okay, this is a general question about safety in the public traffic, and even though there is no law mandating to wear a helmet when cycling, still we think that up to this and this account you should do this because statistics have shown that it reduces the severeness of accidents and blah blah blah, things like that. So that, you have to make really like a general case out of it, which also gives kind of some guidance. What is the goal you're pursuing? What is the facts you're relying on? And that's actually a case where you can also hear experts, not only on comparative law questions, but experts who are technicians and who know about the protective effects of helmets, for example, things like that. So sorry for speaking so long about this question. Now to the question you posed to me. The public good, that's a really important question, I think. So in my understanding, in a democratic society, there can be no material fixed definition of the public good, because that would constitute some kind of dictatorship. If you say, okay, we have this is the public good and I am the one to define it, then I will be the dictator in the end, because I can force everybody to do what I say. So I think what we need is something like an open definition or like a procedural definition of public good, and so this is normally achieved. So a very important part of it is, of course, the parliament and the debate, but it's not necessarily the parliamentary debate, but can also be a public debate, but it must come up with some like general conclusion. It's not like somebody who, like a monarch, decides what is in the public good and what not, and so that's so it's not so easy to distinguish, because of course the legislator also legislates on purely private law in the old sense, like on rules that are meant to solve conflict of interests, and so it's we need some kind of statement or so to declare some act of private law as a regulatory act. So in the examples I gave about sustainability, for example, you can find this in the materials or in the recital of the European directive, and then you have a hint that it's admissible, and also maybe that you have the duty to interpret this kind of rule in a regulatory sense. But without having that, there must be clear indications that something was meant to serve a public interest, and it's not about the judge to define his idea of the public interest in general. But sometimes, I mean, if you have, so it's not that easy as well. If you have some hints from other laws and you have like a general clause in private law, then you can also kind of use this as an additional regulatory instruments to enforce a public interest goal, which has so far been only achieved by other means. So the example we had before the break with financial regulation, then if the German Supreme Court would again change its direction and now also enforce these rules by way of contract law, that would just add another instrument to pursue the same regulatory goal. I hope that this is going in the direction you were interested in. Sure.
To a utilitaristic definition, you'd weigh the outcomes. Is this the best solution, or is that the best solution? And always choose the best solution for the public good. And I'd like to know if is that your view too, or do you have another view about the if we regulate through case law?
Well, that's becoming kind of dangerous territory, because if you equate utilitarianism with economic efficiency, then I would say that you need a clear indication by the legislator for a certain field of law that this concept of weighing consequences is really wanted. So, for example, in corporate law and also financial market regulation, it's very it seems realistic that people think about this in such ways that you compare the utility of people, and that it could be a guiding principle. When it comes to the prevention of accidents, for example, and on questions, so to make a very absurd case, I mean, if you have a very strong notion of efficiency, then it's, for example, a question: why did somebody speed on a highway? What was what could be achieved? And if he was the CEO of a big company who wanted to go to the airport on time to catch a plane to conclude a huge contract, which would help make people 100,000 people into new employment contracts and so on, that would be such a huge gain that he could basically overrun a small child which has nothing to put on the scale. Yeah? And that's certainly not what I think is allowable for a solution in case law, but that's an absurd case. So. So my personal view is that the courts, that you need some kind of connection to some legislative or general intent, and there could be guidance from the Constitution, for example, from general principles, which you could, if you regulate, and there also has to be some kind of mandate for the court. So if the legislator explicitly refused to regulate certain things, it's not allowable that the courts then proceed by way of case law. So that's a bit of a modification of what I said earlier, that I have no problem with judicial activism. That's true as long as there's no clear indication that the legislator wanted to go otherwise. So I still see a hierarchy in the sense that it's the Constitution or primarily EU law, Constitution, legislator, and if there's some freedom, then I have no problems with the courts to do there something.
Okay, thank you.
Okay, so now we have several questions from the audience here as well as online. So I think I'm gonna have the order as such. We're gonna start with question here. Hedda, could you please, or Filippo, could you please give, Filippo, could you please give him, I think he's Henrik, right? The mic. Yeah. And then we're going to have one question from the online participants. And then we have 2 questions from the audience as well, I think, 1 and 2. Is that okay? Yeah.
This is a question for Kristina. I teach private law currently, legal historian, private law in Uppsala. And I just happened to bring this for the train trip. 400 pages of cases for 10 seminars in Uppsala. They have to read 40 pages per seminar of cases. And one will just get used to it. That's my theory. And we'll find a way. As for the case law, one could say that had this been cases from the 40s, 50s, and 60s, especially 20s, 30s, it would have been 40 pages with as many cases decided. What has happened is that judges cannot stop talking. And the judges that talk the most are the professors, who in recent years have gained more access to the courts, the Supreme Court. We have a number of famous professors, one at Uppsala, Håstad, who teaches on our semester. And he usually settles doctrinal disputes. Oh, no longer, because he's no longer the court. But he had a few doctrinal issues that he settled as a judge, that he did not settle as a professor. And I think one issue is that many professors, since they're now gaining increasing access to the Supreme Court, which historically has been unusual in Sweden because they've been viewed with great skepticism from regular judges, is that they bring their cátedra with them and their habitus of being allowed to speak uninterruptedly and unopposed. They can dictate dogma. And they are sort of apostolic succession as the cátedra historically has been. When you bring that into the courts, you bring also an element that historically has been foreign to the Swedish court, possibly more normal in Germany, where it's more doctrinal. I think that is an issue that needs to be addressed, that when you say that comparative law can expand thanks to professors, maybe we should also be a bit hesitant. That professors are not necessarily always the actors that we wish to further the development of the law. They may, in other words, as is the case with this book, they're very happy to settle disputes, not only the one before them, but to address a number of other issues while they're at it. And so that is the current trend in Sweden. They answer usually by 5, 6, 7 questions. There's obiter dicta all over the place. You could actually do copy and paste of this into a textbook. So we can now almost get rid of textbooks in Sweden by just doing copy and paste of the Supreme Court cases. I'm not joking. We actually explain to students that they can do that if they're just creative enough. Now, they address this issue of comparative law. Now, we have many fads in history, in legal history of legal education. We had the social sciences in the 70s. We've had history for many years, legal history. In Stockholm, you've had legal genetics. You will have sustainability, you will have the gender perspective, you will have the comparative. But before you do, and I can agree that it's important, where is the actual debate? We don't even have a discipline of comparative law in Sweden. You cannot write a thesis in comparative law. You can write it in another discipline and do it comparatively. But there is next to no actual debate on comparative law since the 60s, when Åke Malmström, Stig Strömholm, and a few others, Folke Schmidt and Jakob Sundberg, were active in the field. It's been largely dead and moot ever since. In other words, if you want professors and comparative law, I suggest that one of the countries where it's been most neglected historically begins to actually do an inventory and also be mindful of, besides Common Core, besides the functional Zweigert cuts and the French David approach and whatnot, we also have the alternatives, such as the American tendency right now with currents and anthropological comparative law, etc. In other words, competing epistemological paradigms that would actually also contribute towards the debate. I suggest, why not in Sweden have a conference on comparative law? Have debates in the papers, in the journals, etc. I think that would be a great advancement of the discipline. Just a suggestion. Thank you. Oh, I teach at Uppsala. Sorry.
Thank you. Now, the way that awards from decisions from the Supreme Courts are described, the reasonings, the length of the reasonings, they vary, as you say. In Sweden, they used to be short, now they're longer, a little bit shorter than they were perhaps 10 years ago. We see the same development elsewhere, where, for instance, in France, the Supreme Court has changed its style in the reasonings. And the reason for that is that I think that judges gradually become more aware of their role, not only to solve the individual dispute, but to also provide guidance rules for the future. And in order to do that convincingly, they need also to thoroughly motivate why they have come to their conclusion. So I welcome the increased transparency in legal reasonings lately in the Swedish Supreme Court, and I think it's an inevitable development in many other countries. The other issue, to what extent Supreme Courts are influenced by the law in other jurisdictions, I find it extremely interesting to see how the Supreme Court in the UK, English and Wales, refer to the situation abroad. There is a wonderful case about contracted form requirements between two parties, where the Supreme Court makes a very thorough investigation and looks onto the continent and describes what they see and very transparently states, this is rubbish. We will not have this rule. But they've actively displayed the rule, analyzed it, and rejected it. I think this is good. And we see also the Swedish Supreme Court sometimes taking into account the state in other jurisdictions. I think I welcome this trend.
Thank you. And I think we're going to let in a question from the online participants.
I have. Let me see if if I can get this microphone. Do you
Yes,
hear me?
it's
Okay,
on.
good. So thank you. We have a question from a PhD candidate in Foggia, Italy. A brief observation regarding Professor Ramberg's speech. In an interesting point, she said that more law is created by courts, but the more a law is created by courts, the more nationalistic systems tends to become. Does she believe that an expansion of the system of sources can also lead to the opposite process? For example, thanks to the so-called general clauses. So essentially, a question about the role of general clauses, among other things, in your theory.
Let me just point out that I don't know whether judge-made law will tend to become more nationalistic. I don't know, but I am afraid of it. And my point was that we as researchers need to try to prevent that development. And as to the question on general clauses, yeah, general clauses needs to be less abstract and more concrete through case law. This is a very important task of case law. And if legal counsel argues that this general clause should be understood in the same way in Italy as it is understood in, where do I know, Portugal, because we have Portuguese case law, that's good. But then the legal counsel needs to be aware of this. And this is why comparative law is imperative, in order to prevent judge-made law to become unnecessarily nationalistic.
Thank you. Thank you very much. Was I satisfied with that answer? I hope. Yeah.
I don't know, but I was.
Then we have a question from the audience here in that corner. Yeah, otherwise we can start from this end. Afterwards, yeah.
Thank you so much. It was a wonderful opportunity to hear about regulation from Professor Alexander. And I feel honored from Professor Cristina that she mentioned Brazil as an important case scenario to search for these innovations in comparative law, because I did my research in Cornell about access to justice and the precedents in Brazil, since I am a public defender. And I could say in first hand that it's very important. It has many impacts on the lawsuits themselves. Brazil has more than 100 million lawsuits. And the effect is that in 2003, we created a system like the Massima in Italy that was binding, and that was the Súmula Vinculante. But then in 2015, we had the enactment of the new procedural code. And that leads to a very different changing in the conception of judicial making in Brazil, since the effect of these binding precedents is that these little maximas, they become binding and cases can be dismissed in the first instance. So that leads to the impossibility of many plaintiffs to make claims against the Brazilian state, against big corporations. So me as a public defender, and I've been a public defender since 2006, I can assert that this is so important to have someone so insightful, brilliantly tackling the situation in Brazil, because I spent a lot of my time doing the research on that, trying to persuade people to read the comments on the draft of the code and what was the real intent behind it. It's not just to engage in dialogue, it's just to impose a new rule of law, that you would have a jurisdiction limited to just a certain part of the population, but not to the vulnerable, because many, many bad decisions were taken by the highest. We had also good, and that became binding. And the other problem is that the way that we assimilate the system, because when you transplant a system, I went to Cornell pitching to the office that I should understand how to do distinguishing, what is overruling, what are the rationales, so I could have a good discourse as a lawyer, because this is what I do. And then it turns out that most of the judges, they do the copy and paste of the highest decision without doing the distinction, without going to the obiter dictat, without signaling the change that will affect the law. And this empty the law, empty the Brazilian law that is a very rich system of, multiple dialogues from different jurisdictions. So I felt really, really honored to have you engaged in this dialogue in Brazil. And we can talk later about that because I could spend hours here talking about that. Thank you.
Do you have any comments?
Yeah, it's just I fully understand the problems in Brazil to make this huge reform, and because it's about the identity of judges and the whole court system and the whole legal system. It's a big revolution, and law is slow.
But I think this kind of fundamental changes, you can see that in China as well, right? With the Guiding Cases project. Yeah. All right, so thank you, and thank you very much for your comment. And we have one more question from the audience here.
Thank you. I have a question for Alexander. Alexander, I was wondering if defining problems away may be too simplistic. So the question of what is the function of private law and what is the function of public law can be resolved as you did it. And I was wondering about an example. And the example which I want to expose to you is there is a really lively debate in intellectual property law about rights for a purpose, meaning that intellectual property rights have always the purpose to drive innovation. So there is a purpose. And then lawyers, not only lawyers, but also judges, are obliged to interpret intellectual property rights in a way that they will drive innovation. And they come to very different conclusions in comparison to 20 years ago, when the debate between competition law and IP law was still separated. So today, the judgments look very, very different. So that opens the door also to us as normal lawyers, property lawyers, to reflect about the function of property law. And I'm absolutely convinced also property entitlements are rights for a purpose. And you can always factor in the function of freedom, but also the obligation to others, like in neighbor law. So, and then you are in the middle of the whole model of overlapping private and public law. So rights as a purpose, that is my question to you.
So thank you so much for this really important question. So my intention is not to define the problems away, but to show ways how to tackle this. And so on a very general level, it's true that there are some there are many norms which have dual functions or can have dual functions, and then it's really very difficult to sort this out and to see how this works together. And or it can be there are many norms where you can have debates on whether they should serve a regulatory function or just balancing of interests. And I understand. So in my view, IP law is clearly a field of law where we have a lot of regulatory law. So what you said, incentives for more innovation, so that seems to be a very clear indication to me that this is a part of where we have a lot of regulation. And personally, I also believe that property law as such also serves a lot of important regulatory functions. Actually, so in my book I had two main fields of reference. One was sales law and the other was property law. And I think that from my point of view, that property law. Oh, sorry. At least there was no brand on it. That property law is even more important as field of where we find a lot of regulation. But of course, what you said, the model, that's really the problem, to sort out where we still have like only conflicting interests. And so, for example, neighbor law, in my view, is a field where it's more about balancing conflicting interests. But the general purposes and the regulatory purposes of property law, for example, of land ownership, in my view, is something like to assert that the land is efficiently used and that we don't have waste, so that things like that. And of course, sustainability in a very old sense is very important for that already. So there's a big core of what we now kind of develop under this green sign, which was already embedded in a discussion in the 19th century about the use of land and things like that, and the overcoming of the old feudal structures in the Middle Ages, which really were put hurdles to the efficient use of land and to the sale of land and things like that. So that's all very important in property law. And still, of course, there are cases where it's really hard to say, do we have here a regulatory purpose or not? And that's something I think in an ideal world where the court should really openly debate this, and where it should go up to the Supreme Court to decide on this and to pose these questions. And so one of the criticisms of my work, which I understand most, is when people tell me you cannot distinguish this properly. And I would say it's very difficult to distinguish sometimes, but the point that it's difficult to find the borderline doesn't mean that there is no borderline. And but of course, the borderline is also a political question sometimes, and it's not only a question of interpretation of the law and to just to state what is already there, but it's also to make new law. I hope that it's going in the direction which you were interested in.
Wonderful, thank you so much. And I think it's so interesting that you mentioned we have one more question.
So, yeah, I have a question, but
Okay. No, I think we have time for one more question, so I will let the.
Thank you very much. And this is from me personally, not from somebody online. I have a couple actually for both of you. And to Christina, I have a question about essentially you are sort of putting the finger on the fact that the role of the judges have, or especially the Supreme Court justices, changed quite a bit, at least in how they recognize their own role. And I would agree with that. And I don't have really a problem with the fact that they solve doctrinal problems. In fact, I think that the Supreme Court should solve doctrinal problems to some extent. And what annoys me the most is when the Supreme Court is too focused on very tiny minutiae rather than trying to solve some larger questions. What, however, I see as a problem, and I wonder if you would agree with me, or a potential problem, is that if you compare the most activist courts that we know, specifically the Supreme Court of the United States, ideally in our mind, what you realize is that every well-informed American citizen, you don't need to be a lawyer, you don't need even to be a specialist, knows who the Supreme Court justices are. Those names are very famous, they are in the public focus very much, you know what they stand for, you know what kind of theory of the Constitution they have, and so on and so forth. What I see a little bit as problematic in Sweden is that we are going in the direction that you are pointing at, but still keeping this idea that the Supreme Court justices are just civil servants, they apply for their job as if they were going to direct the postal service, and at the end of the day, if you ask a class full of students, do you know the names of the Supreme Court justices in Sweden? They probably would come up with 3 names, 4 names, and then the knowledge would stop there. And you certainly don't know if they have any differences among themselves in how they view the Constitution, the role of the law, unless they are very vocal about it. And in a few cases they are. And that, I think, is a problem of transparency. If you are going to have activist judges, you probably also need to have some public debate about what those judges believe. and how they viewed their job and how they perceived the constitutional role. The other question, which I ask immediately to Alexander, is, well, I appreciated very much your intervention, your presentation. I wonder a little bit how you look at some areas of private law, or some rather features of private law, in which clearly the judge must make some form of public good assessment. There are general clauses is clearly one of those areas. Pactum turpe would be another area in which essentially, depending on which legal system we are talking about, the assessment of what is public good can be done in very different ways, either by a sort of carte blanche referral to the general principles of the system, or by discussing something very similar to ordre public, or if you're talking about filling lacuna, you could even, like in Switzerland, have a clause saying, well, the judge should act as if he were the legislature. So how do you see that sort of connection between where private law tend to, or the judge in the private law situation tend to have to make some assessments which are very close to be actually regulator in the classic sense?
Thank you very much, Filippo. These judges as stars, I'm very hesitant to go in that direction. I think it's more detrimental. I don't like the idea of interrogating the judges before they are appointed. What are your political views? What do you think of this and that? I don't like it. And if you compare to the US Supreme Court, they deal with constitutional matters. I'm talking about private law, which is not as political. And in the instances when the decisions, the rulemakings from the Supreme Court are political, have political elements in it, then it's easy for the parliament, the legislator, to reverse it by statutory law. You gave a very interesting example earlier today when you said, well, roughly speaking, when human rights come into contract law, then also contract law becomes political. But in such cases, it's easy for the legislator to deal with the matter unless it's in the Constitution. Then it's hard. I think you definitely have a point there. And that's when it becomes problematic, when the judges are too activist. But I don't think that the solution to this rather small problem is to make judges disclose their personal preferences in political aspects.
No, not in political matters. I'm not saying that we should ask what they vote for, but we should perhaps ask them, what is your theory about, let's say, the role of statutory law vis-à-vis case law? Questions about legal theory, not about vulgar political debates. I mean, that's...
Okay. Yeah, I'm still hesitant.
So thank you also for this question, because it allows me to clarify something which I left aside so far, and I'm taking the danger that you might not find my theory as convincing anymore afterwards. The thing is, in my view, public good and political decisions are not the same. So also in the balancing of interests, you can have political decisions. So for example, all law that's about the protection of weaker parties, so employment law, protection of children and all these kind of things, there clearly is a tendency to favor some party over the other, and that can also be a political program. So also in Germany, especially rental law. I mean, because it's so important for us, that's what we call like social rental law. And so we have huge rights for for people renting apartments. And in my view, this is still something about balancing of interests, because on the one hand you have landlords and on the other hand you have the tenants. And I mean, they are, of course, if you put this in the general law, then it's very stylized and generalized, but it's nevertheless some kind of conflicting interest. And so you can imagine this like a line. There's this interest, here's the other interest, and you can pick a point on the line. You can be close to one party, you can have the middle solution, or to the other party. And in regulation, it's more like a triangle. So you have, at least if you have private law involved, you have one party who could be the potential enforcer, but it's actually the relation between the state and the other private party, and the state wants to force that other party to do something. And so when judges interpret general clauses, for example, the other examples you gave, you really have to see whether they are in the field of balancing interests and making political decisions there, because, for example, the legislator didn't do that, or whether they want to regulate. And the regulation is something between one person and the state, and who's the addressee of the regulation. And there you have something like a goal which you want to achieve, and you can achieve it better or not. And it's also very often that it's like a permanent goal. So a very easy example, that the goal that nobody gets killed by another intentionally is of course a permanent goal, because even if today nobody is killed, it can happen tomorrow. So this always, you never reach it finally. It's not a final point where whereas if you have these balancing of interest, then you can have a conflict, and then once it's settled, and then people readjust for this, and maybe the wages go down, go up in an employment contract or setting, but that's a completely different situation, and both is political decisions. That's something I would separate from each other, but I don't know if it's going in the direction of what you were interested in.
Thank you for the clarification. Thank you.
Thank you. And thank you, everyone, for all the questions. I think it has been a very interesting discussion. And at least me, I could continue this discussion for a couple of days. But I think that we had a very nice first day of the general meeting. And maybe I can suggest that we can continue discussions at the conference dinner. That will take place at 7:30 at Kung Kal, the restaurant there. And I do believe it is within my power as chair to declare that this is the end of a very successful day. And I hope to see you all tomorrow as well. So thank you for our speakers, really big applause.